Let me start with an example about moot court. I don't know how many of you have run across moot court before. Moot court is a staple of law schools. In pretty much every law school, there's at least one moot court program. Generally speaking, they are run by students, but under the advice, with the advice and in some measure under the control of faculty members, just because faculty members know a little bit more about law than the students do. And the purpose of the moot court is to teach students how to be better lawyers. It's not an academic class in the sense of teaching you substantive subject matter. It helps teach you how to write briefs, and it helps teach you how to argue. Because what happens is you write your briefs, then you argue, and there's a competition, and eventually there's final round, and then you're evaluated by the judges, who are usually start out by local lawyers, and then eventually the final round is usually federal appellate judges. You're evaluated based on your writing and based on your argument. You're not evaluated, generally speaking, based on your research. That turns out to be important for this story. And the question was actually kind of a technical legal question, whether you need to, with a prosecution in order to convict someone of a threat, needs to show the person specifically intended to put the target in fear, or whether it's enough to show that a reasonable listener would have been put in fear. An interesting technical problem having to do with something called mens rea. I don't know if you've run across it. If you go to law school, you're going to study criminal law. Your first year, you're going to hear a lot about mens rea. This is standard legal stuff, and that's why I think the students thought it was an interesting question. The leading precedent was a case called Virginia v. Black. It's a 2003 case which involved cross-burning. The question was, when does cross-burning become a threat? And the reason why aloneness was, in fact, before the court in the first place, is Virginia v. Black had a line that suggested that the constitutional test is indeed purpose. That you need to show that somebody had the purpose of threatening. Other courts had earlier and since said, no, that's not the rule. And that the Supreme Court maybe didn't really think it through when it announced it that way. So there was a disagreement among the courts. Again, so far sounds like a very straightforward legal issue. But it turns out what happened was this came out because students got in touch with a local faculty member and said, there's a problem with our moot court problem. What's the problem? Well, the administration is telling us that we can't include Virginia v. Black as one of the cases in the research packet. And the faculty member says, that's pretty odd. I have this all on very good authority. So that's pretty odd. Why can't you include it? It's the single most important precedent. Because it involved cross-burning. And black students might be upset by this. Now note, this didn't come from any particular students. This was the administration projecting that some students might be upset by the fact pattern of one of the precedents, Virginia v. Black, and that they shouldn't have to read this precedent. But then, of course, the question is, what about the other precedents? Because if there are other cases in the course spec, they have to mention Virginia v. Black. And court opinions usually, when they mention a case, say something about the key facts. Oh, the student said, we were told to take care of that too. We have to redact. We have to edit out the facts of Virginia v. Black from every case that mentions it. And 4 administrators told them the same thing. Ultimately, what happened is they went to a 5th administrator at the advice of this faculty member, an administrator who had actually come from the tenured faculty rather than being an administrator who had gone in through the lecturer route or had never been a lecturer. And the 5th administrator said, that's a very strange demand that you're getting. And within 2 days, it was all revoked. So from my perspective, it was a happy ending, but a not so happy beginning. And I want to start with this because this isn't actually a matter of free speech. There's no First Amendment right in this context to have a particular problem, in part because this is something of a curricular offering. It's done by the students, so it's not actually part of the formal curriculum, but it is subject to the editing of the faculty member. And if the faculty member had said, you can't include that precedent, it's completely not on point. Or if the faculty editor said, you really shouldn't include this precedent. It's just too confusing. Trust me, I've taught a lot of students. This precedent is too confusing. Use this other precedent. That would have been perfectly sound, it seems to me. But what was going on here is because of this concern that has especially arisen, I think, over the last several years about what some people call safe spaces, about having students not feel offended or upset or triggered by material, what happened was the underlying substantive pedagogy of the problem was being destroyed. Students, instead of being taught, look, you have to read the cases. You're a lawyer, you have to read the cases. Some of the cases may involve really bad people doing bad things. That's why they're in court. Criminal law especially. They could involve murder, they can involve rape, they can involve robbery, they could involve cross burning. That's, it seems to me, the pedagogical message that students have to be taught. You know, when you're a lawyer, you can't just tell your client, no, I'm sorry, I can't read that precedent. It's too upsetting to me. And again, I don't think any students actually asked the administration to do this. Administration was being proactive there, just not the good kind of proactive. So that's what persuaded me that there really is a problem. It's a problem not just as to speech restrictions as such. It's a problem about academic freedom and ultimately about academic integrity. And one of the lessons of this example is that academic freedom isn't just an abstraction. Academic freedom is about effective training of students, effective teaching of students, effective learning by students. And it's not just about that, but in considerable measure it is about that. And losses to academic freedom are ultimately in many ways losses to effective teaching of students. Let me give you another example. So this was a flyer for an event at the University of Minnesota. Note the date, January 2015. It was right after the massacres at Charlie Hebdo. The title was, Can One Laugh at Everything? Satire and Free Speech After Charlie. And you'll notice that the panelists were all academics. This wasn't just like student group invites some incendiary speaker. And then the administration says, we don't much like him. No, this is about as establishment as you can get. Some of them were members of the University of Minnesota faculty, 3 of them were. One was from a law professor at a neighboring school, another was an editorial cartoonist at the local newspaper, which makes sense. It seemed like a very sensible panel to have at the time. So here's what happened. Kimberly Hewitt, who was director of the Equal Opportunity Affirmative Action Office, got complaints about the presence of this flyer, that it created a hostile environment for Muslim students because it depicted what supposedly is a depiction of Muhammad. Now, for obvious reasons, we have no idea if this is at all like Muhammad, but because it depicted Muhammad, that this was offensive to students. So she says, well, my office has no choice but to investigate. There are limits on free speech, and that would be where you have harassment of an individual based on their identity. Now, sometimes what people say about harassment, what we think is, okay, somebody's walking behind you shouting epithets at you, or shouting non-epithets at you. You could be shouting, I love you at you. At some point, it becomes harassment. But this wasn't that. In fact, in the sense as an individual, it wasn't about any particular individual at the University of Minnesota. To the extent individuals felt upset, it was just because it was an image of a religious leader. It was a commentary on religion or related to religion as a whole. Still, she says, this might be harassment. We got complaints that they felt it was insulting and disparaging to their faith. Now, when word of the complaints got out, a college administrator sent out an email asking the flyers be taken down. And the dean of the department, I think very much to his credit, said absolutely not. The flyers stay up. My faculty are putting on this event, and you can't censor their descriptions of this event. The investigation ultimately concluded the flyer does not rise to the level of harassment that would violate university policy. But it found that because many people found the poster personally offensive and hurtful, it contributed to an atmosphere of disrespect towards Muslims. And in a letter to Coleman, Hewitt recommended that he communicate that the college does not support the flyer's image of the Charlie Hebdo depiction of Muhammad. Now, if I were the dean, my response would be that I do support that. But I don't insist that everybody take that view. At the very least, though, the dean might say, well, it's not my job to decide whether I support this or not. My job is to create an environment where faculty members and students can discuss all of these issues, whether I support a particular depiction or not. It's not for me as management to tell then what depiction I would support or not, especially if you look at what this depiction is. This depiction is one of the most important images of the last decade. It is something that is of historical significance. It is something that decades from now people will still be talking about and reading and seeing in books and talking about in articles. To say that because some people find this image to be blasphemous, it cannot be displayed at a university, it seems to me is a very, very major step backwards for academic freedom. And again, ultimately for freedom of students to learn and for students to hear all sorts of views, whether there are views that are favorable towards Islam or hostile towards Islam. All right. So this is, I think, a special case of what interestingly would seem to be rediscovering is very old sort of restriction that the Supreme Court in 1952 I had thought had buried in a case called Joseph Burston, but now seems to be coming back, and that's prohibition on blasphemy. So at San Francisco State University, college Republicans were investigated for months for stepping on a Hamas flag. Hamas is a terrorist organization, but among other things, on its flag, it has apparently a passage from the Quran, including, I think, the name of the name of Allah. So some Muslim students complained, saying this we find offensive to us as Muslims because they're trampling on, wasn't actually even a real flag, it was their drawing of the Hamas flag. Well, I can see why some people would be offended, but this is the flag of ultimately a government, of a terrorist organization. It could have been a non-terrorist organization. It seems to me that criticizing governments and expressing your hostility to governments is an important part of what university students should be free to do, whether it's the government of Israel or the government of Hamas, and whether their flag contains religious symbolism or not. At Purdue, a professor was investigated for criticizing Muslims on a Facebook page. These incidents actually do predominantly these days involve anti-Islam speech. And Tufts University held that a student newspaper harassed Muslim students by publishing a critical parody of Islamic Awareness Week. Something similar at University of Chicago. And then just around this hour, William Patterson University, a Muslim student was charged with sexual harassment when a professor who sent out a message affirmatively promoting a film labeled a lesbian relationship story, he sent back saying, he doesn't want to hear that because he thinks homosexuals are perverted. Now, it's not my view that homosexuals are perverted, but it does seem to be his understanding of his religion, and that seems to me to be a view that needs to be aired, whether you agree with it or not. If you disagree with it, you need to be able to explain why it's wrong and not just charge people with sexual harassment for promoting it. This is a different example. Blinn College, which is a college, community college in Texas. This was a sign. I don't think they got very large grant from any outside groups to produce this sign, Defend Gun Rights on Campus by Young Americans for Liberty. That was their sign. Administrators tell students that she needs special permission to display the sign and to collect sign-ups for the club. Now, part of the problem is this was one of those free speech zone type cases where the administrator said, look, we just don't want any speech. It's not like we just don't like your ideas. We just don't want any speech because it's a bother. It's something that interferes with our bureaucratic way of running the institution. So you need special permission just to display a sign and collect signups. But one of the things that they also made clear is the permission might be unavailable because of the message, because the signs support gun rights on campus. Now, there's a big controversy about whether students who have legal licenses to carry concealed guns should be free to carry them on campus. In about 40 states, any law-abiding adult can get such a license, or sometimes even carry a concealed gun without a license. In some of those states, they can carry it on campus. Others not. An interesting question. I don't know what the right answer is. But again, it seems to me that that is a question that should be debated as a matter of academic freedom and not suppressed.